Hello, everybody. Very excited to be here with Ken today. And before we get going, just a couple of housekeeping things. So, first of all, there's a large group of you that decided to get out of the heat and get into the AC to dial in and spend a little time with us today. Super happy to have you with us. I do know that of the 1,000+ people in this webinar, that there are many of you who have yet to join the Academy and become a member. And many of you have probably joined a lot of CLEs through the Academy, but have yet to join this wonderful organization that I'm very proud to be a past president of and very active board member and lecturer for. So I encourage you, reach out to Michelle, join the Academy if you're not a member already, and she'll work a good deal with you and or your firm for firm membership as well. And there's just a lot of great benefits other than these CLEs. One perfect example is if you're an Academy member, you can reach out to me after a CLE and say, hey, I have an idea for a CLE, maybe we can do together. And that's what Ken did. I heard from Ken a couple months ago. He reached out to me and said that he thought it would be a great idea to do this CLE. This was Ken's idea, where we would have a plaintiff's lawyer and a defense lawyer, and we would just talk about the issues that come into play when it comes to negotiating and settling a case. We all know the reality is that 95% plus cases will settle, get resolved before a jury actually comes in and renders their verdict. Knowing that that's the case, knowing that although we always talk about what we're all going to do at trial, because you need to do that to get a sense of the strength and weaknesses of your case and the value of your case, we all know that that's less likely to happen. It's less likely to go to trial and more likely to resolve via settlement. So why not put some serious energy into getting your case resolved early if possible, resolved along the way. And Ken, I thought he had a great idea, and he put together some really great materials, the bulk of which he created in your material packet, which Michelle gave you a link to download. If I refer to a page, or Ken does, that's the PDF number, because it's a 121-page PDF document. But on page 20, there's a list of topics, and those are the topics that we hope to touch on throughout today's course. And then throughout the lecture today, you will see that in the materials, Ken cites to a lot of really good cases on point with certain ethical issues that come up in settlement. Also gives you the actual professional code of responsibility citations and the code itself, so you can go through and do your homework there. We're going to talk a little bit about bad faith and how that can impact potential settlement. I've included a sample bad faith letter that you can all use if you want to send that to another party or to a client or however you want to work on it. And that's on page 113. But we're going to kick it off. We're going to get into it. And as usual, we take questions from 2 o'clock to 2:30. Ken and I will monitor the Q&A. As always, if you've attended any of my CLEs before, you know I like an active and engaged community. So call us out on something if you feel that we're missing it, or you agree or disagree, or have thoughts or have questions. We're all here to help each other. And Ken and I have, many, many decades of experience in negotiating cases, me from the plaintiff side, Ken from the defense. And we're not here to tell you what's right or wrong, but we're here to tell you what we have found to be a successful method from each of our side. And also, I think it's really important as a plaintiff's lawyer to understand what's going on in defense counsel's mind. What are they dealing with when I'm pushing and trying to get a case to get resolved? What does the defense lawyer have to deal with? And I think it's important for plaintiffs to know that. Same way I think that defense lawyers, it's good for them to know what's going on behind the scenes with the plaintiffs when they give a demand. Is it a real demand? Is it not? So that's what we're going to explore today. So Ken, I'm going to kick it over to you just to say hello to everybody.
Sure.
And then we'll get going.
Absolutely. I just want to say how happy I am to be working with Andrew today. I've seen a number of his CLEs. I've seen some of his mentor podcasts. I just had to say that I think Andrew approaches things the right way. Look, I had a mediation a couple weeks ago with Richard Byrne, and he said something to me which made me laugh, but it was true. He said, we all work for Litigation Inc. We're just in different departments. And if you think about that, that really is true, because we don't need to become mortal enemies just because we have a case together. And one of the things I've picked up on from, watching Andrew and reading some of his materials is that he does keep in mind that, we do need each other to resolve this case. If we're mortal enemies and we can't talk, and every time somebody calls on the phone and ends up in a screaming match, we're not going to advance the ball. We're not serving our client's best interests. And that's really the first point I want to make, is that we're all really here to serve the best interests of our clients. So with that said, I'm going to start out with a little bit of talking about some of the ethical considerations, some of the rules that may apply. And then I think Andrew is going to take up some of the other issues that we discussed. And we're going to have some banter back and forth as well, because part of what we want to do today is give each other different perspectives. What Andrew's thinking about, what I'm thinking about when certain things come up in litigation, and how it would help us to understand each of each other's, concerns. So with that said, a couple of rules that come into play, I think, when we're talking about, settlement and settlement ethics. First of all, there's, competence, which is rule 1.1. There's the scope of representation and allocation of authority, which comes up in rule 1.2. Communication comes up in rule 1.4. Truthfulness in statements to others, which is really an important one, is rule 4.1. And then when to settle. Do you settle before a jury selection, or do you wait until trial? And that really implicates rule 3.2. Now, I will say, look, each one of these rules could be a separate 1-hour CLE in and of itself. So I'm not going to go into a lot of detail on each of them. I'll talk about them briefly, and obviously we're here to answer questions later on as they come up. But those I thought were, interesting things to discuss, in the beginning. So first thing is, and this may sound like a silly question, but you have to know who your client is. That's more important on the defense side, I think, but I think it comes up in plaintiff's cases too. For example, you may have more than one person you're speaking to about a case. Now, who's the actual client? Is it the young lady injured in the car accident, or is it her dad who brought you the case and who's staying involved in it to a certain extent? So we need to always remember who is the actual client. For me, the client is the defendant, not the insurance company. But again, there's some massaging that has to be done there, because although the client might be the actual defendant, the company or the person, frequently it's the insurance company that's paying the bill and has the final say about settlement. So there's some massaging that goes on there. But always I have to keep in mind that I'm here to serve the best interest of the client, which is the defendant. And sometimes those take some difficult conversations with the insurance companies, but we have them when we have to. Now, with regard to why I would want to mediate or why I would want to settle a case in the first place, again, benefits to the client, efficiency. Maybe we don't need to go through a 4-week, $75,000 trial if we can resolve the case. There's finality, there's closure, and you mitigate risk, because you're agreeing to, let's say it's a financial verdict, you're agreeing to a number that you both can live with. Whereas if you go to trial, it's a jury who's going to tell you what the case is going to be worth. And then there might be the possible appeal and the wait for, the 2-year wait in the second department these days for the court to rule on your appeal. So there are definitely some benefits. If you're mediating a case, if you're negotiating a case, you have a relaxed evidentiary burden. Okay. You can exchange documents back and forth that you wouldn't necessarily be able to get into evidence at time of trial. You can obtain a financial benefit for the client. From the plaintiff side, it's getting money in its pocket. From my side, it's maybe not paying as much as I might have to if I went to trial. And of course, the unpredictability of trials. Now, competence. I'll just talk about it briefly. Okay. Now, most people know you don't take on a case that you're not competent to handle unless you associate with someone who is competent. But why does that apply to settlements? Let me just point out one thing. Suppose you're a relatively new lawyer or taking on a case in a relatively new area of law for yourself, and you've handled the case very well up till now, but now it comes to settlement. You've got things to think about here. primarily one of which is, what's the actual value of the case? What is a case like this worth? If you've never settled a case like this before, you might want to talk to someone who can give you some input, to give you some guidance. Andrew would be a perfect person to reach out to on the plaintiff side. Say, look, what are the injuries? What's the treatment? What's the recovery been like? Is the person going to be able to go back to work again in the future, or are they going to be out of work forever? Those are things you have to think about, and they affect the settlement value of the case. And you need to be, up on, on what it is that the case really should be settled for, and maybe how best to settle it as well. Now we talk about scope. We'll talk briefly about the scope of representation. Okay. And by that, we mean, what is the client asking you to do? Are they just asking you to get into litigation and settle it early? They've had some conversations directly with the party before and weren't able to get it done. How far do they want you to go? But also, you have to have a conversation with the client about what you're willing to do. How far are you willing to push the envelope? Remember that you've always got an ethical obligation to deal with people honestly and fairly. So if a client is asking you to do things that you're really not comfortable with, you have to look at that and say to yourself, am I really going to be willing to go and do this? Or do I have to have a hard conversation and possibly even maybe withdraw if push comes to shove? Communication. I'll mention communication just for a second. That's Rule 1.4. One of the things that we're supposed to do is keep our client informed about what's going on. And one of the important things you have to, and it's specifically mentioned in the rule, is you're supposed to keep the client informed of material developments in the matter, including settlement or plea offers. Okay. Including settlement or plea offers. Now, I know that we all have conversations with our client going into mediation or going into an important court conference or whatever, and we think we know what the parameters are, what the client is willing to take, what they're not willing to take, okay? I still recommend conveying any settlement offer, any settlement demand to the client so that they cannot say, you didn't tell me, I didn't know. You walked into court saying we wouldn't take less than $1 million. I'm just making this up, of course. And you get an offer of $750. And you say, well, the client told me I won't take less than $1 million. I turn this to Andrew for a second, but I would certainly say, hey, convey that offer to the client. Let the client be the one who turns it down, so that if down the road the case goes south, they can't say to you, I would have taken the $750 if you told me about it. I never knew they offered the $750. From my perspective, same thing. If plaintiff makes a demand, I want to tell my client, my insurance company, and my client both, look, this is the demand. They've asked for $1 million. How do you want to respond? My client may have told me 2 weeks ago, I'm not paying more than $50,000 or whatever, but I'm going to get it from them again. So again, they can't say, I didn't know about the offer. I didn't know about the demand. Next thing I'll talk about is truthfulness in statements to others. And this is a big one. I think everybody knows you're not going to lie to the court. Okay. You're not going to lie to the court. You're not going to lie to a tribunal. Sometimes though, people think that, well, it's only settlement. It's only me and the plaintiff. I can push the envelope. I personally feel, looking at Rule 4.1, in the course of representing a client, a lawyer shall not knowingly make a false statement of fact or law to a third person. Okay. Shall not knowingly make a false statement. First of all, it has to be knowingly. So if you didn't know something, you can't have knowingly made a false statement of fact or law. But if you do know something, you're supposed to disclose it. Now, we're not talking about secrets. We're not talking about client confidences, which is a whole other CLE topic we're not going to cover today. But I'll take it from my perspective. My client has a primary policy and an excess policy. And if I were to go into a mediation and tell Andrew, my client only has a primary policy, there's no excess, and I know that's not true, well, that's a material misrepresentation. So bottom line is, I think just like we tell our clients going into depositions, tell the truth. Always tell the truth. And if you don't know something, say, I don't know, but I'll find out. Now, sometimes it's not an affirmative statement. you know, I'm not telling a lie per se, but I'm omitting something. I'm omitting something which I know to be true. Okay. And there are cases that talk about silence or omission of a fact that the attorney is supposed to tell. First one, which is Slotkin versus Citizens Casualty, is just what we talked about: failure to disclose excess insurance policy before settlement. So the plaintiff settles thinking there's only a primary policy and there's actually excess coverage. The attorney was disciplined. The plaintiff was able to sue for additional funds due to the fraud. There's a case called Cresswell versus Sullivan and Cromwell, where a lawyer intentionally omitted material information from discovery. And the court held in that case in the Southern District that the lawyer could be personally sued for money damages caused by fraud, because again, he knowingly, intentionally omitted information from discovery. In Pendleton versus Pendleton versus Central Correctional Facility, plaintiff settled the case. It was an employment discrimination case. Took the money, cashed the check, and then turned around the next day. I say the next day, but very soon thereafter, and filed a second charge for retaliatory discharge. And the employer's complaint was that the plaintiff intentionally withheld during settlement negotiations the fact that he was going to file a retaliation action based on the same conduct. And although the court didn't sanction the plaintiff, the court did say that a half-truth may be as misleading as a statement wholly false, and that the failure to disclose a fact may be a misrepresentation in certain circumstances. So the moral of the story is just be very careful about what you say, but also what you don't say, particularly in settlement negotiations, because you might find that even omitting a fact when you have a duty to disclose it is in and of itself an ethical violation. Next question is, and this is kind of a simple one, but it does come up from time to time. That's why I included it. What happens if the plaintiff passes away in the middle of settlement negotiations? Okay. You've had some back and forth, got a couple of phone calls, maybe even going to actually go to a mediation session itself, and the plaintiff, you find out, has passed away. There are cases that talk about what happens when a plaintiff attorney settles a case after the plaintiff has passed away without taking all the necessary steps to have, an administrator appointed and substitute into the case. And the bottom line is essentially that when the plaintiff dies, I think most of us probably know the case is automatically stayed. And if you were to settle the case before the administrator is appointed and substitution is completed, the settlement is null and void, and you're back to square one. And there could also be some ethical ramifications as well for not disclosing the fact that the plaintiff had passed away. Okay.
If you're joining us today via podcast, the first attendance verification code is WTL709. Again, WTL709.
Yeah, just a couple of quick things. One of the things we talked about earlier was when to settle the case. I'll just say that Rule 3.2 talks about the fact that a lawyer should not prolong a case without good reason, make a long story short, okay? Some circumstances that require special attention. If you have a client with diminished capacity or special needs, and Andrew can talk more about this later. This is another CLE on its own probably, but multiple simultaneous representation. You have more than one client involved in the same action, or you have separate actions, but the settlement of one might affect for example, the amount of money left to settle the second case and how you have to handle that. On my side of the fence, we talk sometimes about consent policies where the client itself has to, and you see this a lot in med-mal, where the doctor has to consent to the settlement. I also have to worry about the fact that in most cases, the insurance company is the one controlling negotiations, not the client, like I said, unless it's a consent policy. And sometimes organizational clients have certain needs as to how many people you've got to talk to, what the process is for getting settlement authority, et cetera, et cetera. Okay. All right. With that said, I'm going to turn to Andrew now, let him take over.
Great. One of the topics I think it's important to touch on first, because we're not going to be able to get through all of them, is the importance of establishing trust. And it's great when you have it off the bat So let's say now a case falls in my lap and I look and I see the answer is signed by Ken. He's defending it. I would pick up the phone. I'd call Ken. Hey, we've got a case together. Have you a chance to look at it? What do you need? He'd probably say, all right, I'm just getting up to speed. What do you got? Can you send me medicals?
Right.
That starts off, whether I always do that, whether I know the lawyer or I don't. It's really important that if you can, and look, I understand in our profession that you can't trust everybody. Not everybody is nice or pleasant or responsive. One of my missions in speaking with you all for the last, 4+ years on a regular basis is to try and make our legal community a little nicer and working more together with each other. And so a good way to do that is to try and pick up the phone. That's another thing on the list. Emails are okay, but some people don't check their emails. Some people don't respond to their emails. Sometimes you can read into the language of an email what you think is a tone that may not be an intended tone. So it's really important to pick up the phone. If you're a claims adjuster, if you're a defense lawyer, if you're a plaintiff's attorney, pick up the phone and call. And if you don't get a response, call again and drop an email. My firm, we are very diligent about this. We will keep calling and keep emailing and say, can you please just give me the courtesy of a response?
Right.
One of the things that is very frustrating is when you're trying to get in touch with an adversary who just doesn't get back to you. And sometimes you'll finally get that call from the adversary. Oh, yeah, I didn't get back to you because I just, I had nothing to say. I had no authority. I wasn't speaking with my client. I didn't have any information. You know what? That's not a reason, in my opinion, not to get back to somebody. You get back to them and say, I don't have anything yet. I'm keeping you in the loop. Let's follow up. So start, if you have trust already, it's great. If you don't, the way that you establish trust in litigation, in doing what we do in an adversarial situation, is understanding that on the other side, I've got Ken and his firm. He's got a client. He's got to zealously advocate. He needs to get a good result, which means getting the case dismissed or get it resolved for a good number, whatever that is, that's his job. And I can't take it personally that he has to push back on me. The same way it's my job to zealously advocate for my injured client and to try and get as much money as fast as possible and push as hard as I can. Now, we can both do that, and it could get a little tense, but we can both do it by being courteous and respectful of each other. I've got a very big multi-party litigation going on right now where I'm the only plaintiff and I have 2 different defense firms and we're all getting along really well. I've got 2 great defense lawyers and a couple times things have gotten heated. There's a deadline coming up that I could stick to my guns and say, I'm not going to give you an adjournment and you may not get it from a court. But is that going to hurt that lawyer? Probably, right? Am I better off giving it, even if it maybe technically would benefit me not? Yeah, because that's the right thing you do. We're all in the same, as Ken said, litigation Inc. So you can always preface something by saying, I would give you the extension. I'm so sorry. I just can't on this because X, Y, and Z. And sometimes it can get a little tough, but as long as you're trying, by building that sense of trust, and you build it by giving each other courtesies, by giving each other what each other needs on the file. Then when it comes time for the settlement talks, you have that background. And I could say, Ken, listen, do you think this is a case we can resolve? What do you think?
Right.
Do you have a good rapport with your carrier? What do you think would be the best way to resolve the case if they are? And Ken would hopefully say, let me look into it. Let me speak with who I have to and get back to you and actually get back to me. He may say, listen, I may have a difficult claims rep. They're not ready yet, but let's keep trying. Whatever it is, keep that communication going. So that when the time comes when you are talking settlement, either straight up by phone or email or through a mediation, Ken's not going to be mad if we get the case settled. He'll be like, you know what? Andrew's a good guy. He fought hard. It's a fair number for everybody. I feel good what I do with my client. I got no problem with him, as opposed to that person's a jerk. I'm going to do everything I can to make sure this case doesn't resolve. That just doesn't work anywhere. So establishing trust with your adversary, while not always easy, should be a goal you have on every file for everybody. Right, Ken?
Absolutely. I totally agree. And it is right. Pick up the phone. Sometimes the conversations we have, sometimes it's just a couple of minutes on the case, another half hour about how your kids, what's going on, what you do this weekend. But you build that rapport, you build that sense of trust. I mean, there are people who I've done CAD cases with where I know when they call me up and say, Ken, I need X, I know that that's the actual number. They're not bluffing, they're not blowing smoke, but that's because we have that rapport. And when you build that level of trust and build that rapport, it makes it so much easier to resolve cases.
The next topic I want to shift to, kind of doing speed rounds here, is bad faith. Now, we've all heard of bad faith. We've heard of bad faith litigation. I can do a full CLE on it. Maybe sometime I will. But in a nutshell, the reason I want to talk about it is how I use it as a plaintiff to try and get a settlement to come, or at least get talks going. And I'm going to be curious to hear what Ken has to say when he's on the receiving end of this. The idea about bad faith, the way that I'm talking about it, is that an insurance company has a fiduciary duty to the insureds to make sure that a case resolves, if it can, for a fair number. And if you got, let's take an extreme example. If there's $100,000 in coverage and it's a flat liability, horrific injuries that are worth millions of dollars, and the insurance company just keeps fighting you and litigating it and refuses to tender, then you could make an argument that they are in bad faith. And without getting into the details, there's some groundwork you have to lay. But ultimately, what could happen is if you end up going to trial and at the last minute they offer it, you can say no, you can get a verdict. And if you've established bad faith, the insurance company, not the insured, would have to pay the excess amount above the policy. And one thing that insurance companies definitely don't want to do is ever pay any more than what they've provided coverage for. If it's $1 million policy, they're never going to spend a dime more than $1 million. So when you start pulling on some levers as a plaintiff to try and can scare them a little bit, hey, this could come out of your pocket. Additionally, you don't want that. That will usually get the attention of either a lawyer or an insurance company. The other thing that a bad faith letter, which I have in your materials at page 113, a sample you can play with that cites the appropriate case law, is there are cases that I cite that says, you need to tell your insured, you need to tell the defendant in this case that I am willing as the plaintiff to accept the policy limits to settle the case. And your failure to inform them of that can be deemed bad faith. Now, what this does is this puts the plaintiff in a offensive position and defense counsel and the carrier in a defensive position, because then, in keeping with the code of responsibility, as Ken cited, if you're the defense lawyer and or carrier, you are obligated to tell the insured, the defendant or defendants, hey, look, here's a letter we got. You know, they're willing to accept the insurance policy limits. What's your take on it? And if you're in a situation, which we come across in our firm and many plaintiffs' lawyers do, where someone may be underinsured, you could have a wealthy individual that may have $1 million of coverage, but the case could be worth $5 million. And if you send that bad faith letter and say, we're going after your insured who makes 7 figures a year because they didn't have enough coverage, but we're willing to take the policy, they have to have that conversation. And if the insured is sophisticated, the insured may hire their own lawyer. And that lawyer will send a bad faith letter saying, I understand you can get this case resolved for my client within his or her policy limits. I want you to do it. So that will often generate a call. Hey, you want to mediate this case? I got your bad faith letter. It'll often wake up maybe a claims rep or a lawyer that isn't giving as much attention to a file or a case. And I have found a lot of success with that. And I would recommend to the plaintiffs out there that if you're feeling like you're in a holding pattern, maybe you filed your note of issue, no one's returning calls, you're trying to move your case, but no one's talking, and you find that it's close, it may be a bad faith situation. It may be worth the policy. Maybe not. Send that letter. It'll get eyes on it. It'll get attention. Usually what I'll do, and I'm curious what Ken has to say, and then I'm going to let him respond, is I will give my adversary a heads up. Say, listen, just so you know, bad faith letter's coming down the pike, because I don't want that lawyer, as a professional courtesy, to be caught off guard and be like, what are you doing? My carrier's going to get upset that you're bad faithing us. So this way, at least I still say I'm going to do it, but it gives your adversary a little bit of time to prepare however needs to be prepared for.
Sure.
So Ken, what are your thoughts on if you're on the receiving end of my bad faith letter about trying to resolve a case?
Well, like you said, first of all, I would appreciate that you had told me in advance you were going to do it. It would have given me a chance to alert my adjuster and let them know it's coming down the pike. I mean, look, you have to do what you have to do. We all understand that. You know, it is, you have a job to do, and so do I. What I'll say is most of the time, it's pretty rare that I see a really, in my practice, pretty rare I see a really clear-cut case of, you know, actual bad faith. You see disagreements on value, disagreements on liability sometimes, but it's pretty rare that I see actual bad faith. And, you know, one of the things to keep in mind is that the carrier has a duty to settle a case within policy limits if that's a reasonable settlement. What I mean by that is, if you have a client with a sprained ankle, okay, and of course I'm going to be, you know, I'm going to throw out a really egregious example, but if you have an ankle sprain, and I've got $1 million liability policy, and you ask for policy limits, to me that's not a reasonable settlement value for a bad, you know, sprained ankle case. So I would say that's probably not a bad faith case. But I certainly concede your point. I certainly think it raises the attention level on the case, and certainly something I would discuss with my carrier. The one thing I will say, and we'll get into a little bit more later, but sometimes it's a question of the adjuster has so many cases on his or her plate right now, and so many different things, particularly now that we're all coming back to life after COVID, when cases sat around for a couple of years, nothing happened. So that's just a matter of they're overwhelmed. You know, they just couldn't get to it yet. And your bad faith letter might bring it to the top of the pile.
Great. Ken, let's switch gears now to another
Sure.
topic I want to talk on. I have been finding in our practice that we used to have a lot of straight up, what I call a straight up settlement talk. I've got a case. Ken, can we resolve this? You speak to the adjuster, claims rep, you get some authority, you call me up. Here's their response to your demand. I probably have some more. What are you looking for? The trust comes into play. You see what you can get, and we knock out a settlement. I'm seeing that's happening less and less, even with colleagues that I have really good trust with in relationships. And I'm seeing more saying, well, we would agree to mediate,
Right.
and things like that. So what's your take on sort of what's going on out there in the insurance and defense world? And is mediation, is there a reason that a carrier or defense firm may prefer mediation? Are there benefits to that? Are there benefits to straight up settlements? Does it depend? What are you seeing from your side of the V, as they say?
A lot more mediation, as you mentioned, a lot more mediation. And part of it, I think, is that the carriers like to have a neutral third party who can sort of talk, I'll call it talk some sense into both sides. You know, the neutral has no interest in the case, is willing to talk to the plaintiff and say, listen, your number's too high. And we'll come back to my client and say, hey, your number's too low, you know, pushing both sides to the middle. I think part of it is it gives the adjuster, I think it's some political cover, in that they can say, well, the mediator recommended it, you know, or, you know, well, I offered a number of incremental lower values, but we finally got to the place where the mediator suggested, and we were able to get the case done. I think it's a lot more accountability on the individual adjusters now, who have to be able to say why they did what they did, why they spent what they spent. And I think having the mediator's opinion is definitely helpful in that regard.
Great. Next topic. What is your take on demands and offers? And I'm going to preface it a little bit.
Sure.
Many times we will get a call from our defense counsel on a file, and they'll say, yeah, Andrew, the carrier wants a demand, and I don't think you've given me one. You know, can you give me a demand? And my response is usually, are you looking for a demand just to put on the file? Because I know that's part of your reporting and setting reserves for the carrier. You're trying to get an idea of what we're looking for. Or are they asking for a demand because they really want to try and resolve the case? Because to me, that makes a difference. I generally don't like giving a demand if it's just for my adversary to stick on a file. This is the demand, because things can change. And if I give you a demand for $100,000 on a case today, and that goes on the file, but in 3 months, maybe my plaintiff has another surgery or things change, then you'll come back and be like, well, you demanded $100,000, right? So I generally will only give a demand at the time if they're really looking towards settlement. So I'm curious about that, but tied into that, I've heard some people say, oh, well, we always know if a plaintiff gives a demand that they're looking to take half of what the demand is. And I find that to be an interesting take because that's not the case. And then I'll hear people say, your demand is too high. I'm not making an offer against that, which my opinion is that I don't care if my demand, and I like it. My associate, Michael, some of you know as Sally, his usual response is, well, you're saying my demand's too high. You're not going to make a response. Well, I think your offer of 0 is pretty low, and I'm not going to make a response to that. Right.
Right.
So, my thinking is that if you think the case is worth $25,000 on its best day, and I'm demanding $5 million, why aren't you offering me the $25,000? Why do I have to come down with a lower demand? So I know there's a lot tied into that about demands for the file or not, how you view offers and demands. I'd love to hear your take on it.
Sure. Well, first of all, let's talk about demands themselves. We'll ask for a demand. I'll even ask for a demand of the PC. I'll be honest with you, because the reason is what a lot of people don't necessarily understand is that the carriers have to set reserves on every file. I think there's a misconception that the carriers just have these huge pools of money that they can access anytime they want, settle a case anytime they want. And that's not the way it works. Every file in the office has to have, in the office meaning the insurance company, has to have reserves set, both on the expense side and on, the indemnity side. So they've got to set reserves what they think it's going to cost to litigate the case, and they've got to set reserves for what they think it's going to cost to settle the case. Once you set reserves, that money can't be used on any other file until the case is resolved. So if they put up a $500,000 reserve on indemnity, that's $500,000 can't be used on any other case. So it's sort of like budgeting in a sense, but it's very strict budgeting because you can't take from the grocery budget to put gas in the car, if you know what I mean. So I ask for demands frequently to try and get the ball rolling because I know that it might take a while for the carrier to go through their internal procedures to get money, to put money on the file, make long story short. I understand your point about, well, is it a demand really for settlement or is it just a demand to put on the file? But either way, it's helpful to me because I get to report that back to the client and get them think about it and get them to start, putting, because what happens initially normally is no matter what the case is about, there's a reserve put on the file, but it's not necessarily a reserve that would resolve the case because they don't know it's going to take to resolve the case. They don't have discovery yet. They haven't had IMEs yet, whatever. In terms of, and I heard George Silver say this a couple weeks ago, and I really thought it was pretty prescient. George Silver says, I don't care what your demand is because the carrier's only going to pay what they're going to pay. You can ask for $20 million. If they only want to pay $500,000, that's all they're going to pay, So there is some truth to that too. You mentioned the rule of, thinking that they're looking for about half. It's certainly out there. It's certainly a rule of thumb that people sometimes apply. But that being said, like I said to you before, there are people who I know when I talk to them and they say, Ken, I need 475. I really need 475. They're not looking for, 2.25. So again, I think it comes down to what's your rapport, what's your relationship with the plaintiffs on the other side. Exactly.
To play. Yeah.
Right. And also I've had, and when somebody says to me, my demand's, $2.5 million. if that's all they say, then I know that's a negotiable demand. If they come to me and say, Ken, I really need, 1.2 on this case, 1.2 million, then I know that's what they really need, But again, it's what you talked about. It's the rapport, the trust, the back and forth, the appreciation for each other, what we have to do.
I want to share a funny, well, not funny, but just interesting couple of responses I've gotten in the last few months from claims representatives at the time that I've resolved a case with them. And I am what you see, and this is how I talk, and I talk with the adjusters and defense counsel, and I try and have good conversations and get along and get things resolved. And two different senior claims reps on two different cases I resolved this year at the end. And I said, thank you. It was nice working with you. I'm glad we were able to resolve it. They both said to me, thank you for being nice. And I said, what do you mean by that? I am who I am. Are people not nice to you? And they said, you have no idea how many times I get yelled at each day. I get yelled at by plaintiffs' lawyers. And I was like, what plaintiff's lawyer in their right mind would yell at you if you're the one that's going to be deciding how much money to put on the file? They're like, I don't know, but they yell at me, they scream, and it's really unpleasant. So think about that, folks. Think about the fact that there are people that yell. Yelling doesn't do anybody any good. Being contentious doesn't do anybody any good. You can disagree. You could be respectful in your disagreement. And especially when it comes to values and demands, there's no reason to be, for Ken to respond to be like, that's a ridiculous demand, and sort of give a take on it. The proper response would be, I hear your demand. I have to tell you that, I personally think that's high. I don't think the carrier is going to go for it. I don't know if that's your drop dead number. I'm happy to relay it. I don't know if they'll respond to it. You may want to think about it. Is a much better way to respond by saying, well, we're not going to talk to you with that crazy demand. It's more of, I think we help each other by letting each other know what our process is behind the scenes. I'll tell Ken, I'll say, listen, I can work with you on a lot of cases, but on this one, my client is referred by whoever, and they are both on me. They both are insistent on certain numbers. I have to produce the best I can. I just want you to know what I'm dealing with. And the same way that I've had defense counsel say, listen, I've got a really tough adjuster. I'm telling you, they won't respond well to this. I'll do it, but it might help you if you consider. So these are the types of things that bring cases to a resolution, right?
Absolutely.
Yeah. All right. What about high-low arbitration? And I'll preface this by saying and I think any good plaintiff's firm is constantly reviewing the cases that you're working on to see which ones you can move, right? Because your client doesn't get satisfaction until the case is resolved. You don't get paid and get your expenses back as a lawyer until it's resolved. You have to push your cases. And you can't just sit back and say, oh, we filed the note of issue. This will come up in a year for trial. We'll see what happens then. No. That's not how you do things. You need to say, all right, let's make some calls. Let's see. Why wait a year just to say, all right, let's talk. See what you can do. So what my firm does as a practice is we say, look, can we talk? What are we going to do here? Let's try and get this case resolved. You want to talk straight up? Do you want to mediate? Would your carrier consider a high-low arbitration? And for those of you who may not know what a high-low arbitration is, you agree to work with one of the private companies, BAM, JAM, Settlement Solutions, and they have a panel of arbitrators. You agree to submit your case, whatever terms you like. You could have testimony, you could do it just on papers, but it's an agreement that whatever that arbitrator decides is going to resolve the case. And you set parameters. And it's a really, really helpful tool, I find, especially in cases, let's say it's a $500,000 policy, and let's say the case is probably worth somewhere in the twos, give or take. If that's my assessment, we'll say, look, you want to protect yourself on the policy, so we'll make the high 400. We want to protect ourselves on the low. We'll make the low, 50 or 100. And then the arbitrator will decide. If it's a number in between, you agree. If it's higher, you get the high. If it's lower, you get the low. The case is done. You save expenses. I'm a huge fan, but I find that there's often a deep reluctance. It's very rare that I will have an adversary and carrier agree to a high-low ARB. Can you share your thoughts and experience on that?
Yeah, I haven't done a lot of them, tell you the truth. I think you're absolutely right. I think there's a reluctance to do that. High lows are always a little bit tough to begin with because each side always thinks they're agreeing to a number that isn't really that great. You always want, I say you, plaintiff wants the low to be higher and defendant wants the high to be lower. So, there's a lot of negotiation that goes into that as well. But I think on smaller value cases, I could see that it could certainly, be useful. But I'll be honest with you, I haven't done a lot of, I used to do some arbitrations on the motor vehicle side, with the UM and SUM claims, things like that. But beyond that, I really haven't been too involved, to be totally honest with you. But I could see it could have some value, but I could also see why it might be difficult to get people to agree.
Yeah. I get it. I would encourage everybody, think outside the box. Find out what your adversary's concerns are, what they're looking to do, because ultimately everybody wants closure. And right now, a lot of us are not getting closure on our files.
Right.
I mean, we have a case in Queens County, a very heavy case, and we filed our note of issue in December of 2023. And when we've heard nothing, and when we called the court, they said they're just now getting to note of issues filed in July of 2023. This was a couple of weeks ago, and they're looking to schedule pretrial conferences then. So you're just waiting, and we're all waiting. So I encourage everybody, look at your files, see which ones you're sitting on. Be proactive on the defense side and plaintiff side. Reach out to your adversaries, and you'd be surprised. I've resolved a lot of cases in my firm in the last year that if it wasn't me or someone in my firm aggressively picking up the phone, calling the claims rep, calling the lawyer, and finally getting it resolved, it would have just sat there because, like Ken said, your adversary may have hundreds of files, and if you're not pushing them, they're not going to respond. Last topic. We'll try.
Let me jump in 1 second. Just on page 20 of the materials, we've got the topics list.
Yeah.
There's a bullet point. What's the demand? Bueller. I'm showing my age. Okay, I'm showing my age. That's Ferris Bueller's Day Off, if you don't know, by the way. But if you want to move a file, I'm going to need a demand. 99% of the time, I'm going to need a demand before I can get the case into mediation, before I can get any settlement authority even to negotiate directly. I'm going to need a demand. Think of it as like checking a box. Okay, that's all I can tell you. It's exceedingly rare I can move a file until I've gotten a demand from the plaintiff. So when I call, when I email, get back to me so I can at least get the ball rolling. Because without that, most of the time, it's just going to grind to a halt.
Awesome. Well, I'm going to give a couple of closing thoughts, and then Ken, I'll give you the last word, and then Michelle will do the final, and then we'll go to the Q&A.
Sure.
My last closing thoughts are that communication is important, courtesy is important, responding to people is important by phone or by email. If you focus in on those areas, I really think every case can get resolved. Inform your client always. That's my second mantra. My first is preparation. The second is inform your clients, offers, demands, strengths, weaknesses of cases, what you think, what the risks are. You're going to sleep really well at night as long as you've explained everything to your client, whether you're plaintiff's counsel or defense counsel. Reach out to other lawyers, reach out to me, reach out to Ken, reach out to colleagues. A lot of people do that. I do one-on-one complimentary sessions for lawyers. This QR code next to me, you hold your phone, your camera up to it. It'll give you a link to a page where you can schedule one-on-ones with me. You can see my podcast, the books I have out there. All the proceeds go to my charitable causes, you can see. Lastly, I just want to tell everyone, I'm starting my third session of the mentorship program in September. And we've already gone through several rounds, and I've established really good relationships with people. Michelle just put the link in the chat. If you click on the link, It'll tell you what it's all about. And if you're interested, put in the information. It's basically me working with you for 6 months, once a month in Zooms. And we talk about these things and we brainstorm, and I give my thoughts, and it's a good open forum. So I encourage you, if you're interested, to click on that, and look forward to addressing your Q&A. And lastly, a lot of my CLEs are up on my podcast. If you like to listen while driving, that's a good thing to do as well. And I want to thank Ken for reaching out to me. If anybody else has CLEs that they think would be of a benefit to the bar, and hopefully you felt this one was, and I'm so glad Ken reached out to me. That's what you can do when you're a member. You reach out, and as long as Michelle gives a blessing, you can make it happen. So I hand over for a quick goodbye to Ken, and then let Michelle do her final.
Okay, just real quick, guys, liens and loans. Okay, liens and loans. If you have liens, if you've got loans that have to get paid back, let me know early, not the day of the mediation or the night before mediation, because we've gone in thinking we're working on, X, Y, and Z, and instead we're getting A, B, and C, so give me as much information as you can before the mediation so I can try and get you, the money you're going to need, money we're going to need to resolve the case. Thank you.
Thanks, Ken.
Thanks for your attention, everybody. Andrew, great working with you.
You too, Ken. Pleasure. The
Sure.
first question is, what is your view on the use of separate settlement counsel? From the plaintiff side, some plaintiffs' firms will have their settlement person, and that focuses on handling the settlements. But most plaintiffs' firms will just handle it themselves, unless it's a real unique situation where they want to bring in another firm as co-counsel, then they may get involved. But generally, I really don't see separate settlement counsel on the plaintiff side. How about you on the defense side, Ken?
Yeah, I mean, we too sometimes have people in the firm who handle majority of settlements. But I think for the most part, most attorneys handle their own negotiations. And we certainly don't bring anybody in from the outside, in 99% of the cases.
All right. The next question we have from Louise is, what if the offer is $50,000 and not $750,000? Do you disclose it to your client, who might get really mad and raise their demand from $1 to $2 million? So from the plaintiff side, yes, many times we'll see that a case that we think is of a large value and the offer comes in, and not uncommonly, the first offer is usually pretty low. So what we do is, especially at a mediation, I mean, I've settled cases at mediation that settle ultimately for 7 figures, where the first offer is not even 6 figures. And that's not uncommon. It's a strategy that's used by the defense or the carriers. So you need to have a good communication with your client. And I always tell my client, don't worry, the first offer is going to be really, really low. Don't get offended. Don't get mad. This is part of it. But you are obligated to tell them about that $50,000, whether you think they're going to hate it or not. It's all in the delivery. Look, they've offered $50,000. It's a starting point. I don't know if they're going to go higher than 100. They may not. And that's where you should use that opportunity to have a discussion with their client, to see what your client's expectations are. As a plaintiff's lawyer, it's really important, and a lot of plaintiff's lawyers don't do this. A case that Ken and I would agree 9 times out of 10 is worth between $100,000 and $250,000 to settle, and you have a client that's saying, I want $2 million. I understand there's $2 million in coverage. I'm entitled to it all. I know a jury's going to give it to me, right? It's your job to explain to them that that is never going to happen. That even if a jury comes in and awards it, it's going to go on appeal. It's your job to do that. And I would recommend having those conversations earlier rather than later, because you may want to be relieved as counsel. If you truly have a client that just doesn't listen to you about values, about what could happen, that could be a red flag. The last thing you want is to be forced to go to trial. And if you try and get out at the last minute, judges won't let you. They're not going to let you leave a client high and dry when you've got jury selection next week. You're going to have to go to try the case. So if you do want to get out because you have an unreasonable client on either side, defense or plaintiff, you got to identify it early and get out early so they have time to get good representation. Okay, this one's for you, Ken. The Sullivan and Cromwell case, would the attorney be exposed to a claim under Judiciary Law 487? And by the way, all the cases and codes Ken cited are all in the materials, everybody.
I'm going to be honest and say I don't know the answer. I would need to look it up. One of the things I learned as a lawyer is you don't know the answer, tell them that.
Yeah, if anybody knows the answer, they can, pop it in. All right.
Right.
All right, Melissa, when you have opposing counsel who omits facts or misrepresents facts, and you believe it is knowingly, what steps would you suggest taking? I'll give you my thoughts. I'll let Ken give you his thoughts. First of all, you have to confirm, you have to find out if they're lying to you. You can't presume, and unless you really have a basis to know, you can't do anything. You could just presume. You don't want to go hard against somebody calling them out unless you have proof. And if you do have proof, then you would tell them directly, you're lying to me. I know you are. I want an apology. I don't want this to happen again. I want to make sure that we're open and honest. Try and have that conversation first and say,
Yes.
if this is a pattern or if you keep doing this, I'm going to go to the grievance committee. And that's what you do. You go to the grievance committee and you file a grievance and you cite the codes that you now have in your materials that they're lying, they're knowingly misrepresenting, they're violating their code of ethics, and you grieve them. That's pretty much how you handle it. It depends on your relationship, but none of us need to stand for an adversary who's going to lie to us, who's going to berate us, who is going to make our lives difficult, really unnecessarily outside of the four corners of what's reasonable within litigation. So that's how I would handle it. How about you, Ken?
Yeah, I agree 100%. I think always talk to the person before anything else. Always talk to them and say, I think this is what's going on. I want you to correct it if you can. And, that's the first step. I totally agree with you on that, Andrew.
This goes to the establishing trust. I was on trial this year and I observed my adversary mouthing words while his witness was on the stand, and I was in the middle of a cross-examination, and it looked like coaching to me. And so what I did, it was actually my associate who saw it. I said, no, we don't run to the judge. That's like running to the teacher. You tell the adversary what you observed and that you need to stop this right now, or we'll have to bring it. You always want to extend that courtesy of, because maybe you're wrong. Maybe they were yawning, right? And it didn't happen. Whatever it is, have that first communication directly with the person before going any further steps. In my opinion, that's really, really important to do. And you'll sleep good at night, and you want to feel like you haven't done anything wrong. And I think that's the proper way as lawyers we should handle ourselves in litigation and at trial. All right, Larry's asking, if an opponent is clearly under a false impression and erroneously advises the neutral, like the defendant is out of business, is the defendant obligated to advise of the error? I did on the spot. I'm pretty sure I had to. I think failure to correct is akin to affirmative statement confirming what is known to be false. Some colleagues disagree. Look, Larry, in my opinion, if you're in any setting, whether you're in the middle of an argument to a judge in court, or you're in a mediation, but if you feel your adversary is misstating something in a setting that's important, on the record as an officer of the court, or even in a mediation, I think it's your job to respectfully point that out and, take the high road. Say, I'm sure they're not aware of this because they wouldn't have said that, but I just want to bring to the attention of the court, we've become aware that, in fact, their client is in jail. All right. I assume they don't even know that, even if they do. So it's really important. You don't want to just sit quiet if you know something that's wrong, ever. You need to speak up, and it's all about the way that you handle it.
If you're joining us via podcast, the second attendance verification code is WTL224. Again, WTL224.
All right. Dean, I think we talked about this. The pet peeve, how do you handle it when you make a demand and the defense says, your demand's too high and I'm not going to come down. It's the whole bidding against yourself. It's not an area that Ken and I are going to be able to resolve in this mediation between the plaintiff and defense bar. I mean, clearly, and it's the first time I really heard it today from Ken, is that defense counsel is not going to be able to start moving your case unless they have a demand. So, and if it's too high, that's not necessarily our problem. But in general, you need to stand behind your demand. Don't give ridiculous demands. If you think the case is worth, you know, in your mind, you take 200,000, don't demand $3 million.
Right.
You know, is it okay to demand $1 million and settle for 2? That's fine, but be able to justify. So when they say it's unreasonable, you could say, well, how can you say it's unreasonable when I have a life care plan that shows the future cost of care is over $1 million? So what I like to do is I like to be able to justify my demands. And it won't stop my adversary from saying, yeah, well, you know, that's inflated and you know, that's future value. And it's this. Say, look, I'm justifying my demand and I'm not going to come down. But if, let's say, my client calls me up and says, Andrew, I'd really, really like to get my case resolved this summer. You know, I heard they're willing to talk. What can you do? I'm willing to take 200 grand. You know, do you think you can get me that? And I've given a demand of 3 million. I shouldn't sit on ceremony. My clients tell me they want to settle the case. So I have to eat some crow. I have to call Ken back up. I know I gave you a demand of 3 million. I heard you when you said they're not going to talk. So I'm going to reduce my demand. And hopefully this is going to make a difference. And you drop it down to whatever number. I mean, we can't stand on ceremony and principle sometimes. But if you believe in your demand, if you believe you can justify it, then do it. And, you know, we often have a conversation in my firm when we're looking at values of cases where we'll say, you want to give a demand that will tempt the defense or the carrier. You know, you don't want to demand, if you know it's a $2 million policy and you know the case isn't worth 2 million and you demand 5 or 6, it's going to be very easy for them to say, what do you want us to do? You know, we're never going to go there,
Right.
you know? So what you may want to say is, we'll demand the policy and we'll work within it with you. And I think most carriers are not going to say that's unreasonable, even if it's worth less, when you're saying my demand is within the policy, because now it shifts the burden, as Ken spoke about. Now they can resolve it within the policy limits, which they have a fiduciary duty to do if it's fair numbers in there. So
Right.
yeah, there's a lot of strategy involved. You have any thoughts on that, Kevin?
No, I agree with you. I think you said is absolutely right. You know, I couldn't agree more. How's that?
Okay, that's good. So Tiffany's asking a couple questions about how do you overcome defense counsel not wanting to settle? They can't charge anymore. So let's call it out for what it is, Ken. Some plaintiffs believe, and I don't know if it's right or wrong, that some defense firms and or defense attorneys are not interested in settling a case, even if maybe their carrier might or it could be settled, because they see it as a cash cow and they want to get their billable hours in. They know if they make a motion, they could get more billable rates. So they're going to want to do multiple things before talking settlement. Now, I've spoken with other lawyers, and most defense lawyers who I know will tell me, look, I work for my carrier. My carrier wants to resolve the case. That's all I care about, is resolving it. However, there may be others out there that don't. What's your take on this thought process that exists out there?
Yeah, I mean, look, obviously we're supposed to resolve cases if we can. That's our ethical duty. But sometimes though, it's a question of the carrier wants an IME first. You know, they want to see what a neurologist or an orthopedic doctor is going to say. I think that's different from just churning the file though. I personally, you know, I wouldn't ever agree to just churn a file to, you know, take up another couple of hours billing. But sometimes there are legitimate reasons why the case can't be put into settlement negotiations yet.
I'm going to put you on the spot here. Do you think that there are some defense attorneys or firms that will put their own billing practices ahead of other priorities in a case as far as resolution?
I mean, it's a big world, right? I'm sure there are some. I mean, are they supposed to be doing that? No, but you know, I'm sure there are some.
What do we do as plaintiff's lawyer if we suspect that may be happening?
Well, at the top of my head, the first thing I would say is make a demand. Make a demand, because the attorney should convey that demand to the client and the insurance company. And that might get the ball rolling. You know, and you and I have talked about this before. At some point, although I don't like it, I mean, I've had occasionally I've had plaintiff's attorneys say, I want to talk to your adjuster. You know, and now maybe you've already talked to my adjuster before you put the case into litigation. I don't know. maybe you've already got his or her contact information. I'm not thrilled about that, but I mean, if you really feel like as a plaintiff's lawyer, you're banging your head against the wall and not getting any response, maybe you have to say, listen, I'm going to reach out to your adjuster. I'm telling you first, I mean, they can choose to talk to you or not. But maybe you've got to, try that approach. I'm just kind of spitballing right now, but, quite frankly, and I don't want to sound like, I'm a Boy Scout, but I've never seen that happen anywhere I've ever worked. So I'm a little bit, unsure of the best way to approach it. But that would be just one of my thoughts.
Well, I think that's a good point, and it was a topic that we didn't get to discuss in the first hour, is about whether the plaintiff's counsel should negotiate with defense counsel or the adjuster. And in my experience, I have a big, it depends. And again, it goes back to that establishing trust. If it's me and you, it's me and Ken on a file, I'm calling Ken and I'm like, can we resolve this? Ken, do you think I should call the adjuster? Is that easier for you if I go direct? Do you want to handle it? That's how you do it. But we always go to the claims rep if we're not getting a response properly from defense counsel, if they're ignoring us. And for those of you who didn't tune into my colleague Rosa's CLE on the requirements as far as disclosures of insurance information and carrier information, it is under CPLR Rule 3101F that in your insurance disclosures in response to a demand for insurance information under that CPLR provision, you have to give the name and contact information of the claims adjuster on the file. You need to give the whole policy, not just the amount and the carrier and policy number, the whole policy, the limits, and the claims representative's name and contact information. As a courtesy, I think it's always nice to give a heads up to defense counsel, but if defense counsel is not responding or you think that there's a disconnect and you reach out to just reach out to the carrier. I'm just going to give you a little example. I had a case once where I really, really felt I was getting jerked around and they just weren't responding to me. And I asked them, I said, can I have your claims information? I checked the disclosures. I picked up the phone. I went online. I found the main claim number that you call in a claim for the insurance company. I just knew the name of the company. And I kept calling and tracking and giving whatever information I could. Ultimately, I found the assigned adjuster. And when I got through to the adjuster, claims rep, they were very happy to hear from me. Oh, I haven't spoken to defense counsel in a while on this. What do you got? And sure enough, it went right up the flagpole and we were able to talk settlement and get it discussed. So I think talking it out, if you run into a situation like that, go around defense counsel if they're not being responsive to you or you think they're playing tricks. Okay. Amy's asking to me, what do you do when parties are keen to settle and the court is pushing, but you're stuck waiting for liens? So this is about properly building up your case. You need to start requesting lien information early on the file.
Early.
Because it'll hold it up. We have that issue. We'll have a death case that's settled and we want to submit to surrogate's court, but we need the lien information up to date from Medicaid, Medicare, whoever. And it's a nightmare. My partner, Jason, it's like his personal mission to try and get the system changed. He literally spoke to everybody and they're all like, yeah, sorry, don't know, call them, try them. And you just can't get this stuff. So the only answer I have is start early. Everybody needs to know, and the defense should do it too. Who's paying for the healthcare that the plaintiff is receiving? Mm-hmm. Is it comp? If it is, send a letter for a comp lien. Is it Medicare? Is it Medicaid? There's simple forms that you file and send to Medicare and Medicaid requesting a lien amount. Do it and do it early. And then let's say you get a response, and let's say the lien in the case is $15,000, and now you're up to the point of settlement, and it's a year later. You're like, oh, we don't have an updated one. This was $15,000. All right, then put your thinking cap on. Has the client treated since the last date of treatment? Has it been surgery? Has it just been outpatient copays, PT? What are we talking about here? And you can request the bills. You can get the billing in from the providers usually very quickly and see how much the billing is. If the total billing is another $5,000, the lien isn't going to be more than 20. You presume it is. You tell the client, and we've had that. I say, listen, I don't see it being more than 20, worst case scenario. and we shouldn't hold up the settlement on this. But you need to know if it comes back as 30 or 35, that's coming out of your share. We'll work to get it reduced and negotiated and all of that afterwards. But again, it's doing your homework, it's starting early, it's informing your client, and that's how you deal with that situation.
Andrew, quick question for you.
Sure.
Frequently, my carrier wants to pay the Medicare lien directly because the penalties for not paying the Medicare lien are, draconian.
Yeah.
Why do some plaintiffs have a problem with that? In other words, we want to write 2 checks, one to Medicare and one to your firm to disperse the funds. Why do some plaintiffs not want to do that?
I'm not sure. My sense is that they're not confident enough that you'll actually do it, and they're
Okay.
worried that send us the money, we'll deal with it, because then for all they know, you settle the case for $500, the Medicare lien is $80,000. They're thinking, they're gonna send us a check for $420, and they're gonna try and do something on their end with the lien and save some money and keep it in their pocket. That's my sense of probably
Okay.
why they push back. I think
Okay.
as long as you reassure them the process and you let them know that they get copies of the letter, they get copies of the checks, they'll see everything, it's all buttoned down, you have it typed up. We never have an issue with that, and I know some
Okay.
carriers like it. The only issue we ever get really upset about is when our client is under the age of 65, has private insurance, we settle a case, and then when we send in the release, counsel or the carrier says, oh, well, we need a letter saying there's no Medicare lien. Otherwise, we're not distributing. We say they're not Medicare eligible. They didn't get it. They say, well, we still need that letter. And in my opinion, they're not entitled to it. It shouldn't be held up. So I always address that at the time of settlement. There's no holdups, right? You're not waiting on anything. So that's something that bothers me. But as far as
Okay.
making the payment, I think it's okay.
Okay.
All right. You're being asked, what were the cases that you cited for attorney liability? Is that certainly
Yeah, they're
materials? Yeah.
they're on page 26 in the materials.
Great. All right. Igor says, I thought there was no bad faith in New York. Instead, I thought those were called hammer letters. So they have been called hammer letters, but yes, there is bad faith law in New York, Igor. All right. Lori, what are your techniques for countering a plaintiff counsel who set up his clients with unrealistic expectations? The case value is very low, but the client wants to win the lottery. The expectation that was clearly set by their attorney. So I'll touch base on what I do as plaintiff's counsel. Is you've got to be really careful about telling clients what a case is worth. I talk a lot about this. I talk about it in my book on how to successfully litigate a personal injury case, which you can get on Amazon. Click this link, and proceeds go to charity. And I talk about the fact that as anxious as a plaintiff's firm or attorney is to get a case, when you're meeting with that client and they're asking you how much their case is worth, you don't want to give them a number because you don't know what it's worth. And sometimes people feel that they need to say, oh, your case is definitely worth over $1 million because you think that they're going to go with you if you tell them that you're going to get them that much and you want to get the case in the door. And then what happens? The case builds up. It's not $1 million case. Maybe it's $150,000 case. You find out what they told you was, they were in the crosswalk and got hit by a car that ran the red light. Then you finally find out that they were crossing in the middle of the street. The driver had a green light. It was dark out. They were intoxicated in dark clothes. I mean, you just don't know what can come up, right? You don't know how bad, even if an injury is bad, you don't know if they're going to recover, need more surgeries, recover really well. So you have to start the process early by informing your clients. You don't tell them their case is worth more. You start talking about values when it's time to talk about values, when you're at a posture that maybe you can resolve the case, when you see the treatment completed or what may lay ahead, when you have a life care plan if it applies, when you see if there's economic loss, when you see the recovery. So that's what you do. Clearly, our business is not a lottery business. And so it is your job as plaintiff's counsel to quickly dispel plaintiffs of that. Ken, do you have any thoughts on that?
I just think it's a perfect example of why mediation works, because the
Yeah.
mediator can talk to the plaintiff and to the plaintiff's attorney and say, look, the case just doesn't have the kind of value you're thinking.
Right. All right. Next question from Sherry saying that, You have a lot of issues with regard to a plaintiff's attorney not providing you, I assume you're a defense counsel or carrier, with treatment and injury status and medical history documents. You're asking me, do you keep pursuing the plaintiff's counsel or just sit back and wait? So, first of all, shame on those plaintiff's counsels. I just don't understand why plaintiff's counsels just let files sit, especially if you have a defense attorney or a claims rep saying, can you send me everything you got? Do you have more records? You need to give all the records to your adversary. That's how they can evaluate the case. Whatever it is, if they're done treating, if they're not, keep giving stuff as you get it. And if you don't have the records, if I get a call from Ken and he's like, yeah, I'm looking at the file. I see we have records through 2023, but we don't have any this year. Can you get those for me? I'm like, yeah, Ken, I'm on it. I'm working, I'm having my staff. Let's get those records. Ken needs those. I got to get those records so they can evaluate so we can settle the case. So I'm always pushing that. But some plaintiffs, hey, if they're not pushing it or they have too many files or they can't get to it, if your question, Sherry, is do you just sit back or do you keep pushing? That's a matter of how you want to resolve your cases. I give you a lot of credit. If you're proactive, keep pushing. Send them a letter. Say, I'm asking you again. I can't move your case unless you get me this information. I'd like to work with you. This is where you could put out a, extend the olive branch. And if they're not going to respond to that, diary it for once a month. This came up on my calendar. I'd really like to see if this is a case that can resolve, but I can't until you get me the records. Please let me know if you're attempting to, or do you want me just to, here's another thing that we'll say. If we're like, yeah, they went for some more physical therapy, but we're having a really hard time getting the records. Is that going to make a huge difference? Can you just evaluate it on what you have? We're willing to agree to do that and see where we go. You might want to say to plaintiff's counsel, or do you want us just to evaluate it on what we have and leave it at that? That's another thought.
Right.
Any thoughts on that, Ken?
Yeah, just, talk to the plaintiff a couple of times. And if worst comes to worst, make a motion to compel, obviously you have to document it. You have to give, a couple of attempts to try and work it out. And then if worst comes to worst, you need those materials, make a motion to compel.
All right, we have time for just a few more questions. I see some questions about bad faith letter. Eileen, it's on page 113 of your materials. Bad faith letters, in my opinion, you need to modify each one to the specific facts of your case. You'll see the letter I have in your materials is actually my second letter. So in this case, which I just resolved actually last summer, I sent a bad faith letter. And in response, they said, well, we want to get our IMEs. By the time the IMEs got scheduled from last summer, it was this February. By the time we got the reports, it was like May. So I finally get the reports in. Then I sent the bad faith letter that's in your materials where I go through and I use the reports to my benefit. And I say, look, your doctors are saying our client is malingering or full of this or full of that, but let's look at what your doctors also say. They say that they pass all the credibility tests on their evaluation, all the effort tests. They find this objective deficiency. They find that. And then I resent the bad faith letter. I give them a deadline. I cite the law, which is in there. And you know what happened? I sent it to the adjuster I'd been dealing with for the last 2 years for the whole part of the case. I get the supervising claims rep saying, I'm now handling this case. I have your letter. This is the same day I emailed it. Prior claims rep forwarded to me. I'm a supervisor. I'm reviewing it now. We take this case very seriously. I'm going to call you in the next 2 days. She called me up, said, look, I know from the notes you guys are far apart. I think it would really be good to mediate the case. We mediate the case. We settle the case, right? So that's what you hope to have, okay? All right, so it's 2:28. Sorry we can't get to the rest of the questions. Michelle has to do her final bit, but please feel free to reach out to Ken and I. All my information's here. Ken's information is on his CV and the materials. Book one-on-ones, join the mentorship program, listen to the podcast. Let's continue to work together as a community that we're doing, and we can all help each other move our cases, get cases resolved. And then you start doing this as long as Ken and I have, and you start seeing each other again on another case.
You lose all your hair.
Yeah, but... Ken and I had hair back in the day. and then you see each other on the next case. And you're like, all right, this person was a straight shooter with me. Yeah, that person was a straight shooter. And Ken could tell his carrier, I know Andrew. He's a straight guy. Let's see if we can resolve it. And I can be like, yeah, Ken's being straight with me. So that's why it's important to hold your head high, be respectful of your adversary, and work together.
Absolutely.
Just want to thank Ken again. This was great. And I think Ken and I will hopefully be back with maybe additional topics. I think for our community here in the Academy, it's really important that we have these dialogues of plaintiff and defense counsel, and you can see both sides of an issue.
Sure.
And if anybody has ideas or topics that they'd like to hear addressed, or CLEs they'd like to do, or they want to join in, join the Academy first off, and then reach out to us, and or Michelle will make it happen.